Greetings, everyone. Welcome to the DC Bar Pro Bono Center's webinar, Protecting Your Innovation, a four-part intellectual property webinar series, brought to you in partnership with our friends at Steptoe. I'm Daryl Maxwell, Director of Nonprofit and Small Business Legal Assistance Programs here at the DC Bar Pro Bono Center. Before we get started, I'd like to thank my colleague, Lauren Paley, our Associate Manager, and our webinar expert and the backbone of this organization for helping make all of this happen, in regards to webinar implementation and reaching out to all of you. Next, a huge thank you to our friends at Steptoe, Kate Kappert and Lee Kuo, who will be leading today's discussion. This is the second module in a four-part series. On July 7th, you kicked off with Kate, Lee, and my colleague, staff attorney, Christine Kulamani, for an intellectual property overview. Well, today, we will be diving into it on July 21st. We will be diving in deep on patents. On August 4th, we will engage heavily on trademarks and copyrights. And finally, on August 18th, we'll end the series discussing trade secrets. Before we get started, I'd like to go over some of the logistics for today's webinar. First, as many of you may be wondering, this webinar will be recorded. Additionally, you have access to a copy of the presentation for today in the GoToWebinar control panel. If you'd like to share this webinar with a friend, there will be a copy sent when you receive your survey. For questions today, please make sure to use the question box also in your GoToWebinar dashboard. I'll leave it to our experts to explain the intricacies and details about what patents are. But I want to make sure to sort of level set some of the things that are really important about patents for business owners and for folks who are managing and running nonprofits. Patents help you facilitate investment. Patents help businesses defend themselves against attacks by rivals. Patents can help a business stop the theft of its innovations by other companies. Patents can help entrepreneurs form joint ventures and partnerships. And lastly, businesses that protect their intellectual property can achieve, hopefully, greater long-term success. Our friends Kate and Lee will help us understand how to develop and protect those innovations. Lee, I believe you're starting us off, so I'm going to turn it over to you.
Thank you, Daryl, and thank you, Lauren. My name is Lee Kuo from Steptoe & Johnson, and my colleague Kate Kappert and I will present to you the basics of patents. We thank the DC Bar for having us here. And before we start, just to let you know that we're here on our personal capacity, not on behalf of the law firm. And also, this presentation we are providing information but not legal advice. So there are two parts to this presentation. The first part is about how to obtain a patent, and then after you get a patent, you will think about how to enforce your patent. I will present the slides relating to how to obtain a patent, and my colleague, Kate Kappert, will explain to you how to enforce your patent. So you might know this already. The right to patents is actually written in the US Constitution, and as shown on the screen here, the relevant portion reads that the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So how can a patent promote the progress of science and useful arts? It does that because if you apply for a patent, you have to fully disclose your invention to the public so that an ordinary skilled person in the field knows how to practice your patent to make and use your patent. And what is a patent? Patent is a type of property, and like other types of properties, they can be sold, bought, or transferred. The difference is that a patent is an intangible asset. The value in a patent is that it gives you an exclusive right. So the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. It can be very powerful too because for a limited time period, you obtain the monopoly of the technology. We're going to discuss that there are three types of patents. For utility patents, the term is 20 years from the filing date. For design patent, it is 15 years from the date of the grant. And the third type is a plant patent, which is very rare. And if you do have a plant patent, the term is 20 years from the filing date of the application. The actual patent term can be a little bit different because if there's a delay during the patent examination, you may get an adjustment to the term to get more days. Also, for utility patent, you need to pay a maintenance fee to be able to enforce the patent throughout the 20-year term. As I previously mentioned that to obtain a patent, you have to fully disclose your invention. And the other point on this slide is that a patent is territorial, so there's no worldwide patent. So if you want to enforce your patent in a different country, you need to have an enforceable patent in that country to enforce it. As I just mentioned, there are three types of patents. Usually when people mention patents, they actually refer to the utility patents, which is the type that's most common. As you can see on the screen, over 90% of the patents are utility patents. And then you have the design patents, which are less common, less than 10%, and the plant patents are really don't have that many. In general, the utility patents protect the way an article is used and how it works. Comparing to that, a design patent protects the way an article looks. You can have both utility patents and design patents on the same article if your invention involves both the use and the appearance of the article. For example, if you have an iPhone, you probably know that there are many utility patents covering the phone about how it's being used. At the same time, there are also many design patents that cover the appearance of the iPhone. And the plant patent is just a patent that protects a new and a unique plant. Now let's start with the utility patents. So what kind of inventions can be protected by utility patents? Utility patent protects things that are new and useful, including machine, process, article of manufacture, composition of matter, and any new and useful improvement. Just to give you some examples, for example, a machine can be an engine, a process, which sometimes is also called a method patent, can be a method or process having a number of steps for performing a function or accomplishing a result, or steps of manufacturing a product. The term composition of matter can include, for example, chemical compositions or mixtures of ingredients and new chemical compounds. One example of this, I think we know, is a pharmaceutical drug that is a composition of matter. And for design patents, they are the patents issued for original, new, and ornamental designs that protect the design or the look of something. For example, configuration or the shape of a product or the surface ornamentation. Comparing with a 20-year term of the utility patent, a design patent has a term of 15 years from issue. Also, there's no maintenance fee to keep the design patent. The important part of the design patent is in the drawings, which shows the design being claimed. That's a little bit different from the utility patents because, as we will discuss in a little bit more details later, for utility patents, it's the claims that define the scope of the patent. Design patent also generally can be obtained more quickly, and it is a simpler application. It is also usually less expensive to prepare, and there's no maintenance fee. here I just give you some examples of planned patents, because most people will not need to apply for the planned patent. So one example here is a calla lily plant, the other is a strawberry plant. Both of these were issued recently. To get a patent, you have to go through a patent examination process during which your invention will be evaluated under a number of criteria. For example, you cannot patent the laws of nature, natural phenomena, or abstract ideas. One example is that you cannot patent your gene sequence, or that even if you were the one that discovered the law of gravity, you couldn't patent that because that's laws of nature. And the other criteria is that your invention has to be new. This is actually not a difficult criteria to meet, because the novelty under Section 102 requires that the prior art, that the evidence the examiner may use to reject your application under this has to disclose everything in your invention. If your invention has anything new or different, and then that would be a novel, and that would meet the 102 requirement. The challenge that a patent applicant usually faces is in the not obvious, because deciding the obviousness can be a very difficult question. If your invention, for example, has elements A and B and C, even though nobody else had previously combined A and B and C before, if there are disclosures in, for example, 2 or 3 different publications of A, B, and C, the examiner may say, because the elements were disclosed, it's very obvious for you or for an ordinary person in the field to combine them. So the question will becomes whether it is obvious to combine different elements into your invention. And there are many arguments can be made for and against the obviousness to combine. And there are a lot of cases you can rely on to support your argument, to say that your invention is not obvious, even though the individual elements were disclosed before your invention in different publications or articles. The final criteria is about the form and the content of the patent application. As we previously mentioned very briefly, the patent has to contain very clear description of the invention. It has to provide a sufficient detail that an ordinary person in the field can make and use the invention. And this requirement is mainly for policy reason, because if you are getting an exclusive right to the patent, the public has to receive something in return of that exclusive right. So if you have an invention, should you file a patent application? Because a patent application can be an expensive process. It can be a long-term investment. It could involve like several years of working with the patent examiner and the attorneys who is preparing your application. So you may want to consider that the shelf life of the product and the changes in technology and style. For example, if you think the technology is going to change in a year or two, and if the patent takes more than 3 years to get, you probably don't need to file for the patent. And also think about how you're going to use the patent. Are you going to use the patent to exclude your competitors, or are you going to try to license your technology? And also think about whether your invention can cover products outside of your market, because if it can, that makes the invention more valuable. And determine patentability, there can be searches done through the internet or through a professional to see how likely you're going to get the patent, because if through a search you find out that your invention was already disclosed by somebody else, then you probably don't want to spend all the resources to file for the application, which eventually may not get you a patent. And also think about the workaround of the invention. So even if that you are able to get a patent for your invention, if your competitor can easily design their product around your patent, that may reduce the value of your invention. And the next question is, if you decide to file a patent application, and when should you file for the application? There are good reasons to file patent applications early, definitely before the public disclosure or public use or offer for sale of the technology. And since if you disclosed your invention before you file a patent, there is a chance that you may not be able to get a patent because of your disclosure. I mean, in the US, you do have 1 year grace period that if the disclosure was made by the inventor, you can still apply for the patent within a year without the examiner using the disclosure against you. But in some other countries, you may not have this benefit of 1 year grace period. So especially if you're thinking about international patent applications, you want to make sure that you file for a patent application before your disclosure. And the other thing is before you pitch into the investors, it's a good idea to file for a patent application, and then you can tell the investors that your idea is actually patent pending, is being protected from competitors and potential infringers. The other reason to file the patent early is the first to file rule can provide you an early priority date, because that date will be used by the examiner to search for a prior art, the evidence that existed before your application, to evaluate the novelty and the inventiveness of your application. On the other hand, there are also reasons to wait to file for the application because the cost is high and your product concept may change. So you don't want to rush to file for application to spend a lot of money on it, and then later on your product actually is something entirely different from the patent you filed. There are different types of patent applications to consider. The first one is provisional applications, and there are also non-provisional applications, and the PCT applications are used for international filing. So, and also there will be continuing applications. I will discuss them in a little bit more details in the slides following this one. So what is a provisional application? So the provisional application is pretty much a placeholder for you to file a document in front of the patent office. You don't need to have like a formal patent claim in the provisional application. It does expire in 12 months. So it does not get examined. So you don't need to spend too much money on it. And it can also be used to secure an early filing date for your invention while avoiding the cost with the filing and examination. So, and after you filed your provisional application, you can mark your product as pending with the provisional. So why is the filing date important with the provisional application? Because as we just discussed, the examiner will search for prior art to use to evaluate your invention. And prior art is like any evidence that your invention is already known before the filing. And if you have an early filing date, it means there will be less prior art the examiner can use against your application. So it is a good idea to have a provisional application. It provides you a 1 year kind of buffer period for you to think about whether you want to file a real patent application, and also it gives you more time to to finalize your invention, to do additional experiments, maybe to decide the potential of the patent. The provisional application is available to the utility patents, but for the design applications, there's no provisional application. On the other hand, you don't have to file a provisional application. You can file a non-provisional patent application directly. If you do file a provisional application at the end of 12 months, you have to convert that into a non-provisional patent application to start the examination process. And for a non-provisional patent application that's filed within the patent office, it's placed in the queue that will be examined by a patent examiner. It has very specific form requirement. For example, it requires a specification that has a description of the invention. It also requires a set of claims. We will see an example of the claims. The claims are the part of the patent that define the scope of the patent and the value of the patent. And it also requires drawing when necessary. Here it says necessary, but for most of the patent applications that I've seen, they all have drawings to help the further describe the invention. And you need to start paying for the examination fee once you file the non-provisional patent application. The design patent application, the elements is a little bit different, because for the design patent application, as we previously mentioned, the drawings are the most important part of the design patent application, and it has only one claim, and the description of the figure of the drawing, it's there's a certain form of that. So if you want to file a non-provisional patent application for either the utility patents or the design patents, you will need to file them in a certain format. We mentioned the foreign patent applications, especially in nowadays, a lot of companies are selling products in foreign countries, importing products from foreign countries, or manufacturing their products in foreign countries. So if you have an invention that you think is very valuable and potentially can be used in the foreign market, you probably want to think about whether you will also file for patent protection in other countries. It depends on a number of factors, as I just mentioned, like where is the product sold, where is it made, and where are your customers, or who are your competitors, where are your investors. It can be very costly if you file the patent application in many different countries. So you want to take that into account. And different countries have a little bit different criteria for the to get a patent. So you may also want to find out for the specific invention you're trying to patent, whether it's easier or more difficult to get from this other country, and of course to see whether it's possible to enforce your patent in the foreign country, because if they don't enforce it, then there's no need for you to spend the money to file the patent in the foreign country. So the PCT is a tool that you can use to file patents in other countries. It has like pretty much two phases. So phase one, you can file an international application, and then at the end of 30 months from the priority of that application, you can choose which countries you want your patent to patent application to proceed. So even for big companies, they only choose a number of countries. They don't file their patent in every one of the 153 contracting states under the PCT. So I previously mentioned the claims, and the claims are the value of the patent. It defines the scope of the patent, and if there's a potential infringer of your patent, the court will compare your claim to their products to see whether it infringes. And only the subject matter claimed is afforded protection. So if your patent, for example, describe 8 methods of producing a product, and you claim it only one, and then your patent only protects that one method, not the other 7 that's not described in the claims. The claims are written in a very specific way. So if you want to file for a patent, that's why usually it's very difficult to do it by yourself, because the claims are very important part of the patent, and it has specific requirement of how it should be written. For example, in this example, the on the screen, the reason I choose this one because this is the 10 millionth patent, and relating to a laser detection and arranging system. I think that's used very often in the self-driving vehicle now. So you can see that in this claim, first of all, you have to have a preamble. For example, here they're claiming a system, but as we previously mentioned, you can also claim a composition or a method or process or device of doing something. And comprising, that means what elements do you need for this system. So you can see it has like a two-dimensional array, and you have a data bus, you have a processor. So this just gives you an idea of what a patent claims look like. And during the examination, the examiner may reject your claims. In response, you can amend your claim by adding more things, or you can remove some of the elements, because if the examiner says, it's vague or indefinite. The other types of applications are continuing applications. The as we just discussed, if your patent has, for example, 8 different methods, and you filed a patent application for one, and you get a patent, you may also want to think about filing for a patent application for the other 7 methods in that patent application, because if you don't file for patent applications on those 7 other methods, you cannot enforce those other methods against potential infringers. And there are different continuing applications you can file. For example, you can file a continuation application, which means you have the same specification and general invention and the same priority date, but new claim language. For example, if you want to claim the subject matter broader to capture more competitors' products, or you can also claim it narrower. You can also file a division application. Division application is usually for a different invention described in the specification. You will know that because when you file the first patent application, if your claims have more than one invention, you would get an office action from the examiner saying, hey, you have to choose one invention to proceed. And after you choose that one invention to proceed, if you get a patent on that, you can file division applications on the other inventions described in the patent application. And you can also file continuation in part, which means you're adding new disclosure to the specification. But do note that the priority date of your claims will depend on when the claimed subject matter was first disclosed. So if it's disclosed in the new disclosure, you will get a different priority date than the initial disclosure. The continuation is a continuing application is a very valuable tool, because especially your invention is very important. You want to keep the patent family alive, since it can give you some flexibility down the road. For example, if your initial patent covers one aspect of the product, if your competitor tries to design around that product and add in different features, and you can file continual applications to try to capture the new product and if you were able to do that, you can use the patents granted from the continuing application to enforce against the potential infringer. So if it's a really valuable invention, people often keep the patent family alive throughout the entire term of the patent. You just keep filing continuing applications. The process of the patent application, you first prepare the applications. It has very specific requirements, description, claims, abstract drawings that you may need professional help with. And after you have that, you file the patent applications. Once the examiner starts examining that application, it often issues what called office action, telling you like what's missing from the application if it does not grant a patent to you, like why it's rejecting the application. And you do have the opportunity to respond to that and to amend your claims to the extent you need to get the patent granted. And after a few rounds of the office actions, if your application meets the requirement, you will receive a notice of allowance, which will be issued into a patent. Here is just some example patent application timelines. Since it typically takes 16 to 20 months to get an initial response from the patent office, if we use, for example, 18 months as the timeline that you're going to get the first office action, this slide gives you some idea of how long the process can take depending on how you file your application. So the first one, if you file a non-provisional directly, assuming the examination takes place after 18 months, and then the second one is if you file provisional first, it gives you an extra 12 months without the examination. So the examination will start around the 30-month mark. And if you use the PCT and you want to file provisional first, you can file provisional first, and then file a PCT, and then 18 months after you file the PCT, you can choose the U.S. as one of the nation to continue your examination. This will makes your examination timeline becomes longer. They're like good and bad of having to wait for a long time for the examination to begin, but generally it actually provides benefit for you to have a long timeline to get the patent examined, because then you can evaluate the claims you want to include in your patent application. Of course, if you want to get your patent examined fast, there are also options for you to be able to get your patent examined faster than this timeline with some fees. That's the end of my presentation. And Daryl, I don't know if you have questions for me.
We do have some questions, and thanks so much, Lee. I want to first start. One of the questions that that we received was, does the first to file apply with PCT? That was the first question.
I believe so. The first to file is part of the new patent law that became effective in 2013. So because PCT itself is not a patent application, so even if you file, for example, a PCT, and then if you want to get a U.S. patent, you still have to choose U.S. as one of the countries to continue your examination, and at that point the U.S. law would apply. So if you file a PCT and then choose U.S. as the country to continue your application, the first to file would apply.
Awesome, thank you. Another question I had, this was a little bit more sort of general. So I were part of what you were describing, that you wouldn't look to apply for protection in 153 countries. I wonder if there are typical and again, I'm sure this is certainly determined by either the type of product or the type of process that you're looking to patent, but I wonder if there are particular places that are most common. If there are countries where it's most common, where you'd be looking to divert or in addition to the United States, where you'd be looking to protect yourself.
Yes. So in addition to US, typically if big companies want to file patent applications in other countries, they would choose European, because European, there's like a European office. You file one application with the European Patent Office, and they would also often choose Japan, Korea, because these are other countries having more advanced technology and more likely to generate a value for your patent.
Awesome, thank you. And then can you explain the distinction between, if there's one, between small entity or micro entity status?
Yes, there is, I believe there's a difference between them on the USPTO website that if you are different entity status, there's a criteria. For example, like the number of employees within your company have to be smaller than a certain number, and then the fees will be different. So I know there's definitely a small entity and a large entity. I believe there is a micro entity, but let me think about that a little bit, and maybe I can give you a more complete answer at the end of the presentation regarding the small entity and micro entity.
Awesome, that's great, thank you. I've got what I find is a really interesting question. One of the folks on the call asked, how do you make money from your patent? I have some ideas, but I'd love to hear you. I'd love to hear your expertise on that one.
There are like many different ways to make money from your patent, as you probably heard the word patent troll. So some companies, they just have patents, and then they would find companies who make the products covered by their patent to sue their company. I don't recommend that because most people don't like patent trolls since they don't have their own products. I mean, the other way to make money is to license your patent. If your competitor has to use your patent to in their product, and you can reach out to them and say, hey, I can either sue you for patent infringement, or you can pay me a royalty or licensing fee for my technology based on how many products you sold a year for a certain number price of each product. You can also try to find investors for your patent and to develop a product. So there are many ways to make money using patent if it's a really valuable technology.
Thanks so much for that. So we've got some more questions, but I'm going to save some of them maybe for the end so that we can move over and continue our presentation with Kate on how to enforce your patent, which is a great bit of information that we need. So I'm going to turn it over to Kate. Thank you so much.
Thank you, Daryl.
Forgot to unmute myself. Thanks, Daryl. So I actually we'll start off kind of with, we're going to be talking a little bit about that last question too, in terms of monetizing your patents and how do you make money off your patents. So you have a patent, but what do you do with it now that you have one? Patents in general allow you to prevent others from doing what you've claimed as your invention. The fact that you have a patent doesn't necessarily mean that you can practice your patent, which I get is a little bit strange and not necessarily how you would intuitively think of it. An example that I like to give is, say you work for a company and you came up with an invention, you're the named inventor on a patent, but your company is the company that you assign your patent rights to. You then leave and you go to a different company. You can't start doing what you had claimed in your previous patented invention because now you're at a different company and the other company owns that technology. But patents in general, their purpose is to really prevent others from doing what your invention. So you're protecting kind of your technology, your innovation, what you have worked hard to achieve in terms of innovations and developments. What you can do with that is you can leverage your patents in a lot of different ways. So patents not only protect your innovations, but they make you more attractive in a lot of ways and in a lot of different business situations. So with respect to investors, a lot of times investors are going to want to know and ask questions about what does your patent portfolio look like? How many patents do you have? Have you protected this technology in a certain way? So having patents can make you potentially more attractive if you're trying to raise money. If you're at a larger stage and are going to potentially go through the IPO process, your patents are important, and having more patents can make you more marketable in that and help with that process. You can also generate revenue. So having patents allows you to generate revenue through licensing that technology. So maybe you've come up with a great idea, but you don't necessarily have the bandwidth to manufacture the product that you've come up with on your own, but somebody else does. You can license your patent to them and say, hey, larger corporation or company that has more resources at your fingertips, can you please, like, you can make this product, I will give you the rights in this patent to make that product, and in return, you will pay me in some sort of way. That could be a percentage on sales of that product. It could be, which would be like a royalty payment. It could be a lump sum. They agree to pay you some amount of money up front. And you can, because it's your technology, you have the ability to structure that how you want. You can figure out what territories are important to you. Maybe so what parts of the country perhaps, or what industries, how long. Maybe you don't have the bandwidth right now, but you're hoping that you have it and you want to kind of get those rights back. So you have a limited licensing agreement, and then maybe you revisit it later. And there's different types of licensing. There's different ways that you can license your patents to one person, multiple individuals, etc. But licensing is one way that you can monetize your patents and use your patent rights that you work so hard to obtain. It's also a way to reduce or affect your potential competition. It gives you the ability to prevent others from practicing your technology. So if there is competition, you can make them stop doing what you're doing. And there's a couple of different ways to do that. So what does it mean if somebody, how do you determine what does it mean if somebody is infringing on your patent, or if there is competition that's potentially practicing your patent right? Infringement at a high level just means that some other party is practicing what's claimed in your patent in some way or another. And there's different types of infringement. What a lot of times people think about is direct infringement. So another party is making, using, selling, offering for sale your patented invention in the United States. So let's say you have patented a specific product. Let's say we'll just go with a yoga block, for example. And another company makes the exact same block, the exact same shape. It does the exact same thing. So that's direct infringement if they're selling that. But then there's indirect infringement. So that's a party knows that you have a patent and is telling somebody else how to infringe that patent, and is potentially providing them with the components that are required to infringe. So you can think about that. In a lot of cases, you have it with a company that produces components or a product and sells it to a customer with instructions on how to use that product. So maybe you've patented a method for manufacturing something, or specific software operations that wouldn't necessarily be used when the product is shipped, but are used when your eventual end user, your target customer, starts running with the product. And if they follow the instructions that have been provided to them by the company they purchased the product from, they're going to infringe your patent. That's a way of thinking of indirect infringement. And you can also stop that from happening. And then there's contributory infringement. So that's a party is selling a material component of your invention. So they're selling a part of the invention that is really the only purpose is to be used in an infringing way at the end of the day. It's not, for example, it's not at a small enough component level. If there's a screw that is used in a product, and that screw can be used in 50 different things from cars to desks, that's probably not contributory infringement. But if there's a larger item, the main purpose of which is to be used in the infringing system, then that party could be liable for contributory infringement, and that's another way that you can stop competition. So there are a lot of different ways that somebody can infringe, but how do you figure this out? The main thing is monitoring. You track your competition, going to industry events, trade shows, conferences are really great ways to kind of figure out what others are doing. And I realize that in the last year and a half, a lot of these haven't necessarily been happening, but as things kind of pick up and as you can look around and see what other companies are doing, it's a really good way of saying, wait a second, that looks really familiar. That looks really similar to what I'm doing. Maybe I should do a deeper dive into that to see if there's a potential issue here. You can follow other companies' patent portfolios. You can look and see what types of patents other companies are filing for, which may give you an idea of what direction their innovation is headed in. I know that people always like to do this in terms of, if you look at Apple or some of the larger companies, people will look and see what their patents are and then try to guess what their next big technology is going to be based on the patents they're filing. So a company may file a patent on one aspect of a technology. Maybe you have a patent on a different aspect of it, and that can give you a clue that they may be walking into your territory. Monitoring also helps you not just from a potential offensive type action or standpoint, it also helps from a defensive action. So if you're working on developing a product or developing technology, it's also good to know what your competition is doing to make sure that you don't get hit with some sort of patent infringement lawsuit or a cease and desist letter telling you that you're infringing on somebody else's rights. It gives you the ability to potentially monitor what your competition is doing and stay ahead of it by tweaking whatever you're working on to make sure that it doesn't infringe the other company's patent. And this is a very high level, and I realize that this patent probably wouldn't exist, but a way to think about it is if somebody has some sort of invention that says, or a patent on an invention that says, when I mix component A with component B, the final solution turns blue. Well, if you mix component A and component B together, but your final solution turns maybe a different color, is there a way to get around it? Or do you add in component C, and that way you can say that your invention is different and avoid a potential lawsuit? At base, though, monitoring, and something to keep in mind for monitoring, is that it's not a one-size-fits-all approach. All companies, all individuals implement it differently, and it's something that you need to think about and just figure out at a high level who your competitors are, what the market is, what areas you're interested in, and what's the best way for you to monitor it. And it may be that you try something out and it doesn't work, and you go back to the drawing board and you do it differently, or it's just you talk to other people and that's how you find out kind of what others are doing. You don't necessarily have to be scouring patents in order to be successful at monitoring. A lot of it is just kind of keeping your ear to the ground and having an idea of what's going on in the industry that you're interested in. And so you find out through your monitoring that your patent's being infringed. What do you do next? Well, a lot of times when you think of a lawsuit, like lawsuits are expensive potentially, and often. So what do you actually want? What is your end goal? Is your end goal to get monetary damages? If so, how do you get that? How do you figure out how much money you can and are willing to spend in order to get that return for infringement? One way to think about it is the life of the patent. How much longer patents have a lifespan of 20 years, give or take, depending on some examination things that could occur that could make your term a little bit longer. But if you assume about 20 years, did your patent just issue? Is it possible that this other company will be infringing for 20 years? If so, you may be able to get a higher amount of money. If your patent is going to expire in a couple of months, maybe there's a different way that you want to approach the situation. Do you want to stop your competitors in the marketplace? Is it something where, you know, it would be you want to be the only one who's doing this, you want to have the only product out there that is this type of product? If so, maybe you file a lawsuit against them. Maybe you ask for money, maybe you just try to get an injunction which would stop them from being able to infringe your patent. Or maybe you assess licensing and say, look, I'm okay with you doing this, but recognize that I'm the one who came up with the idea first, and I want you to give me some amount of money. And maybe you can avoid litigation in its entirety by following a different path. So litigation isn't the only way to handle the situation if you find out that your patent's being infringed. So once you kind of figure out what you're looking for, and you should do due diligence. And that means make sure that when you're going to threaten that there is infringement, that you actually know and have done research to kind of support that argument. And this should be more than just, looks like this company is doing it. A lot of times this is the step where lawyers, if they aren't already involved, become involved and will help you make sure that you have all of your ducks in a row, in the sense of you have all the proper ownership rights in your patent. Everything is squared away with how your patent has been assigned to you. And also, you may want to buy the competitor's product, take it apart, do a teardown analysis, and figure out if it infringes. And then your next step may be to contact the infringing party. And this is always kind of a questionable decision. And again, not a one-size-fits-all approach. You can file a cease and desist or demand letter that says, company A, you infringed my patent. This is what my patent covers. I want you to stop doing it now. And you may threaten litigation. The reason I say that depending on the situation, some people can be hesitant about doing this, is that there's always the possibility that you send that letter and then the party says, I definitely don't infringe. And depending on who they are, they may turn around and file what's called a declaratory judgment action against you, saying that the court should find that they don't infringe. That doesn't always happen, but it's something to just kind of keep in mind as you're weighing your options about the best steps. Oftentimes, demand letters are great. And if you're looking at licensing and you're not threatening litigation and you just want to start a conversation about it, this could be a good way to get that conversation started. You can also file a lawsuit. And some of that is just figuring out where to file the lawsuit. There's different forums that you can file patent litigation suits in, and the timing and what you're looking for in terms of timing and expense, different depending on where you file. You could be looking at anywhere from 18 months to several years for a patent litigation case. So in terms of patent litigation forms, patent infringement actions are federal causes of action. So in the general court system, you will be in the federal court system as opposed to state courts. So that would mean that you'd be in what are federal district courts, where there are judges that are appointed by the president, and depending on the state, you have different numbers and different districts within the state. So Delaware only has one, and then Texas has, you can imagine, more. California has more districts within it. There are venues in the district court system that are more familiar with patent cases, and there are venues that are less familiar with patent cases. And that also could affect how quickly your case goes. We'll talk a little bit about jurisdiction and how you get it at a high level, but in looking at kind of the districts with the increased patent cases, a lot of them are where you may think, for Delaware, a lot of companies are incorporated in Delaware. That's one of the ways that you can bring a lawsuit or determine where you can bring a lawsuit, which is why a lot of patent cases are filed in Delaware. Same with Northern District of California. If you think of Silicon Valley, a lot of companies are located there, so you have a lot of patent litigation there. What that means is these courts are much more familiar with patent cases. So when you're dealing with your case, you'll often be dealing with a judge who may not have a technical background, but has a much higher familiarity with the nuances of patent law and with the technology, as opposed to somebody in a district court that has never had to handle a patent case or doesn't really have experience with the technology. There's also the International Trade Commission. The International Trade Commission is a federal agency in DC, as opposed to district court judges or appointed judges. It's under there are administrative law judges who run the hearings, and this relates to imported products. So if you find out that your patent is being infringed not by a company in the United States or by a company in the United States who imports the product, maybe they manufacture it overseas and then import it into the US, you may be able to bring a case at the ITC. And the main differences between the two, the judges are different. District court is, you can have a bench trial, which is just for the judge is going to hear it, or you can have a jury trial. Jury trials you get as a matter of right if you're seeking monetary damages. At the ITC, you don't actually get any monetary damages. What you get is the potential for the product to be excluded from entering the United States. In some situations, this could be a bigger threat to a company. If you tell the company who's infringing that they're no longer going to be able to bring their infringing product into the United States, it's not just that they may have to pay you money, it's that potentially an entire line of their business could be shut down and they may bring it into the United States. Or that may be a reason to file in the ITC instead of district court. District court, you generally have two parties, or you have plaintiffs and defendants. At the ITC, you have complainant, which is similar to your plaintiff. It's the patent owner who's asserting infringement, respondent, the company that is being accused of infringement. You also have a third party that weighs in and is supposed to represent the public interest. They're called the Office of Unfair Import Investigations. They're not in every case, but are in some. I realize we are running out of time, so I will try to speed up through some of these. So I'll skip to kind of what litigation covers as a whole and your general stages so that you have a general idea and some things to just think about in terms of enforcing patents. So in litigation, you have what's called the discovery period. You have fact and expert discovery. Fact discovery is between the parties. This is, if you picture the courtroom TV shows where you have somebody pouring through boxes of documents, this is fact discovery. Now in the world of computers, most of it's done electronically through e-discovery. But it's basically where you and the other side are going to have to collect all documents related to the case and the patents and potential infringement and produce them to the other side. People will look at them and use them to figure out the infringement positions, damages positions, and also assess whether your patent is valid. What will likely happen is if you accuse another party of infringement, they will come back and say, even if we infringe, your patent shouldn't have issued from the patent office. It was disclosed in some other manner. And that's called they'll challenge the validity. And so that's the invalidity issue that will come up. Just kind of things to think about as you're going forward. And even if you don't think you may end up in litigation at some point, the fact discovery process is going to uncover a lot of times emails. So just always good to make sure that you don't say things in emails that 10 years from now, you don't want some attorney somewhere to be reading about what you think about your patent, the case, or anything else. Just kind of a caveat to think about as you're in general in life and in terms of litigation. So you have expert discovery. In patent cases, you're going to hire experts both to help assess infringement and also to figure out the money that's associated with it. And then there's also claim construction. The judge will figure out technical disputes related to what the terms of the patent mean. You'll go through trial and then appeals. There's also just kind of on the other side of things very quickly. If you are sued, as I said, you could file a declaratory judgment action. or if you receive a cease and desist letter, you can file a declaratory judgment action saying that you don't infringe or that the patents are invalid. There's also a way to challenge patents at the US PTO, the Patent Office, which is just limited to an invalidity challenge. And you can also, on either end, be on the side of licensing negotiations. If you're told that you infringe, you can say, hey, I'll give you money for your patent. So it's a two-way street. But recognizing we're running out of time, I can stop now. And if there's any questions or anything if there's still time, I can answer them now.
Thank you so much, Kate. We can take probably a couple quick questions, and thank you again for all this really great information. I just wanted to mention there were a couple of questions about how do we get, how does one get assistance if you're either confused about this or think you might want to seek patent or apply for patent protection. I've mentioned in the chat, but you can always go to the Pro Bono Center's resource page and get assistance through our now more regular remote small business clinics. You can go to www.lawhelp.org/DC/NPSB for more information. But I know one of the questions that I actually thought was a really interesting one was, do you guys have any feedback on either applying for patents or sort of keeping track of your patents through a service? I'm just going to use the one that they mentioned, which was InventHelp, but through a service that you would use that wasn't necessarily working with an attorney.
So in terms of the question, just to make sure I understand it, keeping track of your patents without working with an attorney?
Well, I think it's more so utilizing like one of the services that are recommended, like InventHelp or other services. I'm just thinking it might be akin to LegalZoom, which is a question that we get all the time. And if you had any sort of thoughts about it.
I personally have not given it a lot of thought. I think that using other services and platforms to kind of keep track of and monitor can be helpful. It just depends kind of what you're looking at doing and how many patents you have and kind of what your portfolio looks like.
Okay, and then so one of the questions was about essentially how to, what the process is or how difficult it might be to revise a patent. Let's say there was, you were looking to sort of add either a partner in a business on a patent application, how you might do that, and if it was something that was difficult to do.
So go ahead, Lee.
Go ahead, Kat.
No, I was actually going to say I defer to Lee some on this, but I think that it can, adding inventors can be difficult. You can, through continuations, I think you can do it. Depending on if you're trying to change ownership, that's a more of a straightforward process. You can assign patents to different companies. You can add additional individuals, et cetera. From that, in terms of if you want to say that somebody else may have had inventive rights, I think that's kind of, there are two kind of separate questions there in terms of changing who actually came up with the idea versus who actually has ownership in it if your company changes. And if it's the latter, that there is a process for doing that, and you can file a request to assign the patent to somebody else or add somebody else onto it.
Yeah, I agree with Kate. I think there are procedures at the PTO you can use to correct inventorship during the patent application. There may be like a form or something you need to submit to the patent office to add an inventor. But one note is the person you want to add has to be an inventor of the patent, because in the US the inventors they have to contribute to the patent. It's not because he or she is a partner of the company to get added to the patent application. So to be an inventor, yeah, he or she has to actually be contributing to part of the invention.
Awesome. That's exactly what I think we needed to hear. So thank you very much for that. I think with that, let me just say, Lee and Kate, thank you so much for all of your sharing all of your expertise today. And we went over a few minutes, but I think we made up for it in great information for all of you guys that are listening today. To all of you guys listening, thanks so much for joining us here at the Pro Bono Center with the help of our friends at Steptoe. We can all virtually applaud for Kate and for Lee, and you will get an email from the Pro Bono Center asking for just your thoughts and feedback on this particular session on patents. Again, we've received a lot of great information on this. You'll be receiving that survey. Again, you also have an option to receive, you also have the opportunity to sort of take a look at this and maybe review some of the portions of the presentation that you might want to brush up on. Thanks again to Lee and to Kate and to the entire team at the Pro Bono Center for making this happen. Please join us again for a topic that everyone who is registered has been sort of waiting for, our trademarks and copyrights discussion on Wednesday, August 4th at noon. Thanks again. Have a wonderful day. Take care, everyone.